Welcome to Primary Sources. I'm your host, Jason Beats. This podcast will examine the primary sources behind today's biggest stories. On this episode, I will read and discuss the Supreme Court's decision in Whole Woman's Health v. Jackson, which allowed a Texas law to take effect that effectively ends the right of a pregnant person to choose whether to obtain an abortion after 6 weeks of pregnancy. Under the law, known as SB 8, any person other than an officer or employee of a state or local government entity may bring a private lawsuit against anyone who performs an abortion after the 6th week of pregnancy, or against anyone who knowingly engages in conduct that aids or abets the performance or inducement of such an abortion. Plaintiffs who win their case against those who perform or aid such an abortion will receive at least $10,000 under the law. The Supreme Court issued its decision on its shadow docket, a mix of emergency motions and other expedited cases that haven't received full briefing or oral argument. So without further ado, let's hear what the Supreme Court has to say about the Texas anti-abortion law. Supreme Court of the United States. Whole Woman's Health et al. v. Austin Reeve Jackson, Judge et al. On application for injunctive relief, September 1st, 2021. The application for injunctive relief, or in the alternative, to vacate stays of the district court proceedings presented to Justice Alito, and by him referred to the court, is denied. To prevail in an application for a stay or an injunction, an applicant must carry the burden of making a strong showing that it is likely to succeed on the merits, that it will be irreparably injured absent a stay, that the balance of equities favors it, and that a stay is consistent with the public interest. The applicants now before us have raised serious questions regarding the constitutionality of the Texas law at issue, but their application also presents complex and novel antecedent procedural questions on which they have not carried their burden. For example, federal courts enjoy the power to enjoin individuals tasked with enforcing laws, not the laws themselves. And it is unclear whether the named defendants in this lawsuit can or will seek to enforce the Texas law against the applicants in a manner that might permit our intervention. The state has represented that neither it nor its executive employees possess the authority to enforce the Texas law either directly or indirectly, nor is it clear whether, under existing precedent, this court can issue an injunction against state judges asked to decide a Texas lawsuit under Texas's law. Finally, the sole private citizen respondent before us has filed an affidavit stating that he has no present intention to enforce the law. In light of such issues, we cannot say the applicants have met their burden to prevail in an injunction or stay application. In reaching this conclusion, we stress that we do not purport to resolve definitively any jurisdictional or substantive claim in the applicant's lawsuit. In particular, this order is not based on any conclusion about the constitutionality of Texas's law, and in no way limits other procedurally proper challenges to the Texas law, including in Texas state courts. And now we turn to the dissents. The first dissent is written by Chief Justice Roberts, with whom Justice Breyer and Justice Kagan join, dissenting. The statutory scheme before the court is not only unusual, but unprecedented. The legislature has imposed a prohibition on abortions after roughly 6 weeks, and then essentially delegated enforcement of that prohibition to the populace at large. The desired consequence appears to be to insulate the state from responsibility for implementing and enforcing the regulatory regime. The state defendants argue that they cannot be restrained from enforcing their rules because they do not enforce them in the first place. I would grant preliminary relief to preserve the status quo ante before the law went into effect, so that the courts may consider whether a state can avoid responsibility for its laws in such a manner. Defendants argue that existing doctrines preclude judicial intervention, and they may be correct. But the consequences of approving the state action, both in this particular case and as a model for action in other areas, counsel at least preliminary judicial consideration before the program devised by the state takes effect. We are at this point asked to resolve these novel questions, at least preliminarily, in the first instance, in the course of 2 days, without the benefit of consideration by the District Court or Court of Appeals. We are also asked to do so without ordinary merits briefing and without oral argument. These questions are particularly difficult, including, for example, whether the exemption to sovereign immunity recognized in Ex parte Young, 1908, should extend to state court judges in circumstances such as these. I would accordingly preclude enforcement of SB 8 by the respondents to afford the District Court and the Court of Appeals the opportunity to consider the propriety of judicial action and preliminary relief pending consideration of the plaintiff's claims. Although the Court denies the applicant's request for emergency relief today, the Court's order is emphatic in making clear that it cannot be understood as sustaining the constitutionality of the law at issue. But although the Court does not address the constitutionality of this law, it can of course promptly do so when that question is properly presented. At such time, the question could be decided after full briefing and oral argument, with consideration of whether interim relief is appropriate should enforcement of the law be allowed below. Next, we turn to the dissent written by Justice Breyer, with whom Justice Sotomayor and Justice Kagan join, dissenting. The procedural posture of this case leads a majority of this Court to deny the applicant's request for provisional relief. In my view, however, we should grant that request. I agree with the Chief Justice, Justice Sotomayor, and Justice Kagan. Texas law dictates to private individuals the power to prevent a woman from obtaining an abortion during the first stage of pregnancy. But a woman has a federal constitutional right to obtain an abortion during that first stage. Planned Parenthood of Southeastern Pennsylvania v. Casey, 1992, Roe v. Wade, 1973. And a state cannot delegate a veto power over the right to obtain an abortion, which the state itself is absolutely and totally prohibited from exercising during the first trimester of pregnancy. Planned Parenthood of Central Missouri v. Danforth, 1976. Indeed, we have made clear that since the state cannot regulate or prescribe abortion during the first stage, the state cannot delegate authority to any particular person to prevent abortion during that same period. The applicants persuasively argue that Texas's law does precisely that. The very bringing into effect of Texas's law may well threaten the applicants with imminent and serious harm. One of the clinic applicants has stated on its website that due to Texas's SB 8 law, it is unable to provide abortion procedures at this time. Planned Parenthood, South Texas. And the applicants, with supporting affidavits, claim that clinics will be unable to run the financial and other risks that come from waiting for a private person to sue them under the Texas law. They will simply close, depriving care to more than half of the women seeking abortions in Texas clinics. We have permitted those whom a law threatens with constitutional harm to bring pre-enforcement challenges to the law where the harm is less serious and the threat of enforcement less certain than the harm and the threat here. I recognize that Texas's law delegates the state's power to prevent abortions not to one person, such as the district attorney, or to a few persons, such as a group of government officials or private citizens, but to any person. But I do not see why that fact should make a critical legal difference. That delegation still threatens to invade a constitutional right, and the coming into effect of that delegation still threatens imminent harm. Normally, where a legal right is invaded, the law provides a legal remedy by suit or action at law. Marbury v. Madison, 1803. It should prove possible to apply procedures adequate to that task here, perhaps by permitting lawsuits against a subset of delegatees, say those particularly likely to exercise the delegated powers, or perhaps by permitting lawsuits against officials whose actions are necessary to implement the statute's enforcement powers. There may be other not very new procedural bottles that can also adequately hold what is, in essence, very old and very important legal wine. The ability to ask the judiciary to protect an individual from the invasion of a constitutional right, an invasion that threatens immediate and serious injury. As the Chief Justice writes, this court should not permit the law to take effect without assuring the applicants and the respondents an opportunity first and fully to make or to refute these and other arguments supporting the request for an injunction. For these reasons, and for the reasons stated by the Chief Justice, Justice Sotomayor, and Justice Kagan, I dissent. Next, we turn to Justice Sotomayor, with whom Justice Breyer and Justice Kagan join, dissenting. The court's order is stunning. Presented with an application to enjoin a flagrantly unconstitutional law engineered to prohibit women from exercising their constitutional rights and evade judicial scrutiny, the majority of the justices have opted to bury their heads in the sand. Last night, the court silently acquiesced in a state's enactment of a law that flouts nearly 50 years of federal precedents. Today, the court belatedly explains that it declined to grant relief because of procedural complexities of the state's own invention. Because the court's failure to act rewards tactics designed to avoid judicial review and inflict significant harm on the applicants and on women seeking abortions in Texas, I dissent. In May 2021, the Texas legislature enacted SB 8, the Act. The Act, which took effect statewide at midnight on September 1st, makes it unlawful for physicians to perform abortions if they either detect cardiac activity in an embryo or fail to perform a test to detect such activity. This equates to a near categorical ban on abortions beginning 6 weeks after a woman's last menstrual period, before many women realize they are pregnant, and months before fetal viability. According to the applicants, who are abortion providers and advocates in Texas, the Act immediately prohibits care for at least 85% of Texas abortion patients and will force many abortion clinics to close. The Act is clearly unconstitutional under existing precedents. The respondents do not even try to argue otherwise, nor could they. No federal appellate court has upheld such a comprehensive prohibition on abortions before viability under current law. The Texas legislature was well aware of this binding precedent. To circumvent it, the legislature took the extraordinary step of enlisting private citizens to do what the state could not. The Act authorizes any private citizen to file a lawsuit against any person who provides an abortion in violation of the Act, aids or abets such an abortion, including by paying for it, regardless of whether they know the abortion is prohibited under the Act or even intends to engage in such conduct. Courts are required to enjoin the defendant from engaging in these actions in the future and to award the private citizen plaintiff at least $10,000 in statutory damages for each forbidden abortion performed or aided by the defendant. In effect, the Texas legislature has deputized the state's citizens as bounty hunters, offering them cash prizes for civilly prosecuting their neighbors' medical procedures. The legislature fashioned this scheme because federal constitutional challenges to state laws ordinarily are brought against state officers who are in charge of enforcing the law. By prohibiting state officers from enforcing the Act directly and relying instead on citizen bounty hunters, the legislature sought to make it more complicated for federal courts to enjoin the Act on a statewide basis. Taken together, the Act is a breathtaking act of defiance of the Constitution, of this court's precedents, and of the rights of women seeking abortions throughout Texas. But over 6 weeks after the applicants filed suit to prevent the Act from taking office, a Fifth Circuit panel abruptly stayed all proceedings before the district court vacated a preliminary injunction hearing that was scheduled to begin on Monday. The applicants requested emergency relief from this court, but the court said nothing. The Act took effect at midnight last night. The court's inaction has had immediate impact. 2 hours before the Act took effect, one applicant reported that its waiting rooms were filled with patients urgently seeking care while protesters were outside shining lights on the parking lot. Then, at midnight, the Act became law and many abortion providers, including applicants, ceased providing abortion care after more than 6 weeks from a woman's last menstrual period. Since then, at least one applicant has stopped providing abortions entirely. Planned Parenthood, South Texas. Today, the court finally tells the nation that it declined to act because, in short, the state's gambit worked. The structure of the state's scheme, the court reasons, raises complex and novel antecedent procedural questions that counsel against granting the application just as the state intended. This is untenable. It cannot be the case that a state can evade federal judicial scrutiny by outsourcing the enforcement of unconstitutional laws to its citizenry. Moreover, the district court held this case justiciable in a thorough and well-reasoned opinion after weeks of briefing and consideration. At a minimum, this court should have stayed implementation of the Act to allow the lower courts to evaluate these issues in the normal course. Instead, the court rewarded the state's effort to delay federal review of a plainly unconstitutional statute, enacted in disregard of the court's precedents through procedural entanglements of the state's own creation. The court should not be so content to ignore its constitutional obligations to protect not only the rights of women, but also the sanctity of its precedents and the rule of law. I dissent. And finally, we turn to Justice Kagan, with whom Justice Breyer and Justice Sotomayor join, dissenting. Without full briefing or argument, and after less than 72 hours thought, this court greenlights the operation of Texas's patently unconstitutional law banning most abortions. The court thus rewards Texas's scheme to insulate its law from judicial review by deputizing private parties to carry out unconstitutional restrictions on the state's behalf. As of last night, and because of this court's ruling, Texas law prohibits abortions for the vast majority of women who seek them, in clear and indeed undisputed conflict with Roe and Casey. Today's ruling illustrates just how far the court's shadow docket decisions may depart from the usual principles of appellate process. That ruling, as everyone must agree, is of great consequence. Yet the majority has acted without any guidance from the Court of Appeals, which is right now considering the same issues. It has reviewed only the most cursory party submissions, and then only hastily, and it barely bothers to explain its conclusion, that a challenge to an obviously unconstitutional abortion regulation backed by a wholly unprecedented enforcement scheme is unlikely to prevail. In all these ways, the majority's decision is emblematic of too much of this court's shadow docket decision-making, which every day becomes more unreasoned, inconsistent, and impossible to defend. I respectfully dissent. That concludes my reading of the Supreme Court's opinion and dissents in Whole Woman's Health v. Jackson. For those of you who only wish to listen to the decision, thanks for listening. If you want to hear my thoughts on the decision, you're welcome to stick around. This may very well be the worst Supreme Court decision of my lifetime. For the record, I turned 30 last month. The Supreme Court, in a 5-4 decision on its shadow docket, decided a legislature can enact an unconstitutional law as long as the law is enforced exclusively through private litigation, because there is no one a potential defendant can sue to prevent the law from taking effect. That can't be right. This decision could allow a state to enact a law that violates any constitutional right, including freedom of speech, freedom of religion, or freedom of the press, so long as it's exclusively enforced through private litigation. That is a terrifying prospect. The Supreme Court also gutted the ability of courts, itself included, to engage in judicial review, including to protect constitutional rights, one of the primary benefits of having an independent judiciary in our system of checks and balances. You may not agree that a woman should be allowed to legally obtain an abortion. You may believe that the Supreme Court shouldn't hold that the U.S. Constitution includes an implied right to an abortion as previously held in Roe v. Wade. But if you want the Supreme Court to reverse Roe, it would have been far better for it to do so directly, after it considers Dobbs v. Jackson Women's Health Organization, a case the Supreme Court has decided to hear that will receive full briefing and oral argument, which will likely take place this fall. In that case, the Supreme Court will consider whether all pre-viability bans on elective abortions, violate the Constitution. With regards to abortion, I do believe that a pregnant person should be allowed to legally obtain an abortion before the fetus is developed enough to be able to survive on its own. The decision whether to terminate a pregnancy is incredibly personal. Ideally, I believe a woman should notify and consult with the potential father prior to deciding whether to terminate a pregnancy, unless the father is physically or emotionally abusive, or the pregnancy was the result of sexual assault. Potential parents need to consider if they are financially, emotionally, and psychologically ready to accept the responsibilities of raising a child, and if not, whether they believe adoption is a viable option. Of course, these decisions should be made before engaging in procreative sex in the first place, but that doesn't always happen. Sometimes medical tests indicate an unborn child might have serious medical problems, and potential parents need to decide if they would be able to care for a child with those additional needs. I agree with the judicial doctrine that finds that some fundamental rights, like the right to marriage, are protected by the Constitution, even though they aren't explicitly stated. I have no problem accepting abortion as one of those rights. I believe we have now entered a new era of American politics, where the fight over the legal right to abortion, with its passionate supporters and opponents, will take center stage in political races across the country. I don't look forward to that, given how divisive the debate around abortion has been. But with Roe effectively overturned, and likely soon to be officially overturned, the fight will move from the judicial to the political arena. On the next episode of Primary Sources, we will examine the Women's Health Protection Act of 2021, a proposed federal bill that seeks to protect the right of a pregnant person to receive an abortion. That was a pretty heavy episode. Thanks for listening.